The statute of frauds is a law that exists in every state, and under the statute of frauds, a real estate contract for the sale or purchase of real estate, must be in writing to be enforceable. Enforceable means the parties may be forced to comply. The statute of frauds applies to contracts that cannot be completed within 1 year. So the statute of frauds does not apply to leases of 12 months or less. The purpose of the statute of frauds is to prevent problems associated with oral or verbal contracts. That's the purpose. The law sets forth the length of time parties are given to file a claim or a lawsuit for breach of contract. And that's called the statute of limitations. Statute of limitations is the length of time parties are given to file a claim or a lawsuit against the other party. All contracts contain 5 essential elements to be legally valid. There must be offer and acceptance, also known as mutual agreement or meeting of the minds. It is an offer by one party, the offeror, that is accepted by the other party, the offeree. An offer is a proposal containing a promise and requesting something in exchange. Acceptance is a promise made by the offeree to be bound by the terms proposed by the offeror. The offeree accepts the offeror's proposal. That's acceptance. An offer may be withdrawn by either party before communication of acceptance. Offers are withdrawn, and they can only be withdrawn if the other party has not yet accepted and communicated their acceptance. A counteroffer, also known as a qualified acceptance, is a rejection and terminates the original offer. A buyer who receives a counteroffer is not obligated to respond, and he's free to make an offer on another property. A seller who makes a counteroffer but then receives a new offer from another party must first withdraw the counteroffer before accepting the new offer. Let me repeat that. A seller who makes a counteroffer but then receives a new offer from another party must first withdraw the counteroffer before accepting the new offer. Consideration is the next requirement. Consideration is something of value. Each party must give something, and each party must get something. Consideration is the give and get. Earnest money is not consideration. Earnest money is not required in a sales contract. It's included in most sales contracts, but it is not required, and it is not considered the consideration. Another requirement is that all contracts must be in writing and signed. That's required by the statute of frauds. Contracts for the sale and purchase of real estate must be in writing and signed. Contracts must have a legal purpose or lawful objective. And contracts must be between legally competent parties. All parties to the contract must have legal capacity, which means they must be at the age of capacity, and that's age 18 in most states. and they must have the mental capacity to understand the consequences of their actions. A contract with a minor is voidable. So the 5 requirements of a contract are offer and acceptance, consideration, legal purpose, must be in writing between legally competent parties. And remember, a contract with a minor is voidable. Let's talk about valid, void, and voidable contracts. A contract is valid when it contains all the essential elements. A contract is void when it has no legal force or effect because it lacks one of the elements. So when a contract lacks one of the 5 elements, it is void. One or more of the 5 elements, it is void. A voidable contract appears valid, but it may be rescinded or disaffirmed by one of the parties because that party is a minor or because that party was subject to duress, fraud, or misrepresentation. An assignment is a transfer of rights and duties in a contract, but it does not mean that the liability is assigned. An assignment transfers rights and duties, but not liability. The transfer in an assignment may be to a third party and can be made without the consent of the other party unless the contract includes a clause that forbids an assignment. An example of an assignment is a sublease. A novation is a new contract replacing the original contract, transferring rights, duties, and liability. A novation is a new contract. The root word is nova, which means new. A novation is a new contract that replaces the original contract. Both parties to the original contract must consent to the novation. When we talk about delivery of a contract, delivery refers to the intent of a party to transfer a document to another party, or the intent of a party to hand a document over to another party. Whether it's handing a hard copy or handing an electronic copy, delivery refers to the intent of the party to give the document to another party. Acceptance is the expression of a party receiving an offer to be bound by the terms of the offer. The offeree accepts the proposal offered by the offeror. The acceptance must be made within the time stated in the offer. Offers expire, and they're given an expiration date or an expiration time. And if the acceptance does not come within that time, it's not an acceptance, or it's not a valid acceptance. Acceptance must be made within the time stated in the offer. Now, some offers specify that the acceptance is not effective unless a signed or initial copy is received by the broker or the offeror within a certain time. A breach of contract is a violation of any of the terms or conditions of the contract without a legal excuse. They broke their promise. That's a breach. Now, there are 2 ways to file a lawsuit for real estate contracts. Someone can sue for specific performance, or they can sue for damages. A suit for specific performance is a lawsuit asking a court to force the other party to perform the duties they promised. Specific performance or a suit for specific performance is the only option for a buyer if the seller decides not to sell. Also, an injured party may sue for damages, asking a court to order the other party to pay for any costs and hardships suffered by the person seeking damages because of the breach. An injured party may sue for compensatory damages, which is money awarded by a court for actual damages. Compensatory damages are limited to the amount of money lost or denied because of the breach. Another possible remedy for breach is for one or the other parties to accept liquidated damages. Liquidated damages is the amount of money available to liquidate or settle any damages. A sales contract may limit liquidated damages for a seller to the earnest money provided by the buyer. Liquidated damages are only available to the seller in a real estate sales contract. Another remedy might be to sue for punitive damages. These are exemplary or vindictive damages designed to punish the party being sued. Now, besides breach of contract, a contract may be discharged or terminated for other reasons. One of the other reasons might be impossibility of performance. It's legally impossible for the parties to perform what they promised, or an act required by the contract cannot be legally accomplished. Another reason a contract can be terminated is mutual rescission, which is a written and signed agreement by all parties to cancel. It is a mutual agreement by the parties that, hey, we just want to cancel. Rescission means terminating or canceling a contract as if it had never been made. Rescission returns the parties to their original positions before the contract, and any monies exchanged are returned. Mutual rescission would be acceptable if there are major problems, such as the house burning down before closing, or substantial issues that need repairs and are discovered after it goes under contract and the seller doesn't want to make the repairs or can't afford to make the repairs. Mutual rescission would not be acceptable if the buyer simply decides they don't like the home any longer and the buyer wants to purchase a different home, or if the seller decides, they just don't want to sell anymore. That would not be acceptable. Mutual rescission would not work in those cases. Death of one of the parties might terminate a contract as well. Some contracts can be canceled by the death of the party, but only if no one is left to perform. Death does not cancel all contracts. Think of a 99-year lease. Someone's going to die during the term of the lease, and it doesn't necessarily cancel the lease. So death can terminate some contracts, but only if no one is left to perform. Let's also remember that electronic signatures and paperless transactions are legitimate transactions, and they are equivalent to paper transactions. Documents transmitted electronically are considered written documents. Electronic signatures of the parties to a transaction are considered legal and binding.